Good morning. Welcome to Vanik YouTube classes. Master out here for carrying on the discussion on important questions for civil service examinations. Today we shall discuss some important questions related to judiciary. There are concept based questions and also previous year questions. We are discussing different types of questions for different aspirants. Those who are raw, those who are beginning their career, they will be helpful. Those who are already prepared, they will also be helpful by watching this video, because they will get some top questions. Previous year questions are asked somewhat difficult. Okay. And we have already introduced judiciary, what constitutes judiciary, what roles are played by judiciary, and why judiciary is a significant branch of government, a democratic government. An independent judiciary is a sine qua non in a democracy. So we'll discuss the various questions related to that. Should we start? Okay, very good. Now we'll start Judiciary 2. Judiciary 2. Look at the first question. Judiciary 2. Any public spirited person okay, or organization can move the court for the public cause by filing a petition in which the following stances. Here it is talked about public interest litigation. Public interest litigation is an innovative instrument in the hand of PIL, is an innovative instrument in the hand of judiciary to ensure complete justice. Article 142 empowers the Supreme Court of India to do complete justice, to issue decrees and orders for complete justice, and I think PIL has its root in Article 142. Through PIL, public interest litigation, the traditional modes of lodging a case are in the Supreme Court and other courts has been done away with. The locus standi, or the aggrieved parties, should make a plea or make a complaint to the judiciary has been done away with. PIL is an innovative instrument. In fact, it has been borrowed from United States of America with the initiative of some prominent judges in 1980s, including the then Chief Justice of India. Okay, so there is this talk about where it can be lodged. Which of the following instances? So P.N. Bhagwati, the then President Chief Justice of India, P.N. Bhagwati, and other such prominent judges, including B.K. Krishna Iyer. There were other judges also who took the effort, who made the effort to initiate PIL, which is doing marvelous things in India, which has revolutionized the justice delivery mechanism and has been helpful, has been considered a powerful instrument to provide social justice, at least to those who were once upon a time unable to access to justice due to their inability, both financial and educational. Therefore, the PIL has been lodged, and it is now a very popular instrument of accessing justice. And it can be lodged, it can be filed in the Supreme Court under Article 142, that's right, in the High Court under Article 226, yes, and in the Court of Magistrate under section of the Code of Criminal Procedure Code, which is popularly known as your BNSS, Bharatiya Nagarik Suraksha Sanhita. Okay, all of these. D will be the answer. Okay. So this is the question. All public spirited person or organization can move the court for the public cause by filing a petition in which of the following circumstances. Okay, now we'll come to number 2. Which of the following included are included in the original jurisdiction of the Supreme Court? Original jurisdiction of the Supreme Court is mentioned under Article 131. And what do you mean by original jurisdiction? Original jurisdiction means court has exclusive jurisdiction to those subjects. No other. It hears these cases at first instance. These cases cannot be moved to other courts. It is the original, means it hears the cases but the matters at first instance. It has exclusive jurisdiction. So under Article 131, basically the federal disputes are covered under original jurisdiction of the Supreme Court. The federal dispute means dispute between the federating government and the units or the states. So dispute between Government of India and one more state will be obviously under original jurisdiction. A dispute regarding elections to either House of Parliament, no, that is the original jurisdiction of the High Court. A dispute between the Union Government of India, not at all, because there will be no, because Union Territory is not a unit of federation, it is a part of the central government, it is administered directly by the central government. It is completely under the direction, control and superintendence of central government. So it is not a part, it is not an autonomous unit, rather it is a part of the central government, it is under the direct supervision of the center. So there is no dispute if there is no at all. A dispute between two or more states will be a viable option. So 1 and 4 are the federal disputes, they come under, and also disputes between center and one or more state on one side and one or more states on the other side may be a federal disputes, and it comes under the original jurisdiction of the Supreme Court. But let me tell you something very important thing in this connection, that interstate river water disputes, although it is a matter of disputes between the states, but it does not come under the original jurisdiction. It has been put under Article 262, where the Parliament appoints, or under Act of Parliament, a river water tribunal is appointed to settle the disputes. So it does not come under, and matters referred to Finance Commission of India also does not come under the original jurisdiction. Pre-constitutional treaties, they do not come under original jurisdiction. So some matters are accepted in this connection. Okay, so 1 and 4 is the answer. Let us see the options. Yes, 1 and 4, answer will be C. Answer will be C. Question number 2, answer will be C. Question number 3. A retired judge of Supreme Court cannot act as a judge of the Supreme Court for a temporary. He can act, he or she can act under Article 128. The Chief Justice of India may request the service of a retired judge for a temporary period, and he is appointed as the judge of Supreme Court for a temporary period, and he gets some compensatory allowances. So 128 empowers the Chief Justice of India, obviously with the prior sanction of the President. So that is an incorrect statement, because it mentioned cannot. High Court judge may be appointed as an ad hoc judge of the Supreme Court for a year. Under Article 127 empowers the Chief Justice of India to appoint any judge of the High Court in consultation with the Chief Justice of the concerned High Court and with previous sanction of the President of India. Ad hoc judge is appointed when there is a absence or is a lack of quorum in the Supreme Court for carrying out its proceedings. When the permanent judges are finished, are engaged completely, and it requires other judges for some other cases, then the Supreme Court may ask a High Court judge to work as ad hoc judge under Article 127. So it is 2. So 2 is correct, only 2B. Very good questions. Now we'll come to the consider the following statements. The Supreme Court has original jurisdiction in any dispute between the Government of India and one more state. We have already discussed it. So that is correct. Statement 1 is correct. The Supreme Court has original jurisdiction in any disputes between the Government of India and any state or state on one side, and yes, that I was telling you. The Supreme Court has original jurisdiction of any dispute between Government of India and any corporation or individual on one side and on one or more states on the other side. No, that is not a case at all. The Supreme Court has original jurisdiction in disputes between 2 or more states. That will be a correct statement. I think it is 1, 2, 4. 1, 2, 4. 1, 2, 4. Yes, 1, 2, 4 will be the answer. Yes. Okay. So question number 4. Answer is B. Question number 5. In which of the following categories of cases the Supreme Court of India has power to decide? Very good question. A reference made by the President on a question of law or that is 143 or is advisory jurisdiction. Here the Supreme Court advises, not decides. Reference under Article 143. Article 143 that the Supreme Court decides, not advises, not decides. Under Article 143, and the advice tendered by the Supreme Court may not be binding upon the President of India. But a case involving interpretation of the Constitution, that is there, various cases, or Article 21 has been covered under many cases, A.K. Gopalan cases, Maneka Gandhi cases. So interpretation means decision. What will be the exact interpretation of the article or the provision concerned? A case involving a substantial question of law of general importance, yes, that is also a decision. A case where the constitutionality of a law has been challenged, so that is also the Supreme Court takes the decision whether the particular law violates the Constitution or not. If it violates, then it will declare the law as ultra vires or void. So in the 2, 3, 4 cases, the Supreme Court has the power to decide. In 2, 3, 4, yes, answer will be D, not 1. Okay, that is answer D, because in the first statement the Supreme Court does not decide but advise under Article 143. Now look at question number 6. The Supreme Court of India can sit only in Delhi. No, Article 130 empowers the Chief Justice of India to decide the seat of Supreme Court at any other places except Delhi. So that is not prohibited. So it cannot sit only in Delhi, it can sit any place in India as decided by the Chief Justice of India with the previous sanction of the President. So statement 1 is incorrect. Statement 1 is incorrect. Okay. Now the statement 2, Supreme Court of India can sit in any place other than Delhi which the Chief Justice of India may appoint with the prior. Yes, as I am telling you, that is correct. The Parliament may make provisions for conferring supplemental powers upon the Supreme Court. Yes, extra power can be given. 2.3 B. Parliament can extend the jurisdiction of Supreme Court, but cannot decrease it. Okay. Okay, so number 6 is B. Question number 7. In the appointment of the judges of Supreme Court, the recommendation of the Collegium consisting of the Chief Justice of India and 4 of the senior most judges of the Supreme Court is binding on the President of India because it is so provided in the Constitution? No. Remember, the Collegium system is not provided in the Constitution, rather it is invented by the judiciary in the third judge case in 1998. So it is a judicial invention. So that's good, wrong. There has been consistent practice for a long time. That is also not long time. You cannot say it since independence. So it's may not be the correct statement. It has been laid down by the Parliament. No, there is no statutory or constitutional recognition to Collegium system so far. And it has been laid down by Supreme Court. Yes, that will be a correct statement. D. Number 7. Question number 7, answer D. Question number 8. Which of the following statement regarding the exercise of judicial review is not correct? Statement regarding exercise of judicial review. A case must be brought before the Supreme Court regarding the validity of a law. That's correct. The judicial review is not a suo motu power. Suo motu power is not a suo motu power of the Supreme Court. So that is correct. Unanimous opinion of all the judges. No, majority of opinion. That is wrong. Majority of opinion. Legislative enactments and executive orders may be struck down by Supreme Court. Yes. The power is implicit. Yes. In Article 13. Remember, except Article 13, there are other articles which also gives the power of judicial review to the Supreme Court. Article 32, and there are number of articles, 245, and there are number of articles you will see. Okay, so that will be correct. B is incorrect. Okay. Next, number 9. Article 151 of the Constitution lays down that the law declared by the Supreme Court shall be binding on all courts within the territory of India. Therefore, the Supreme Court is bound by its earlier decisions. As the expression all courts include Supreme Court? No. The expression all courts does not include Supreme Court. It includes all courts except Supreme Court. It is not bound by its own decision and can reverse. Yes, that is called revisionary jurisdiction. So Supreme Court has revisionary, it can review its own decision. Power to review its own decision is laid down in the Constitution under Article 137. So Supreme Court can reverse its own decisions time and again. Many examples are there. The statement of A.K. Gopalan has been reversed by later decisions, Ajan Singh case, and in Goloknath case the decision made regarding the inviolability of fundamental rights, but in Kesavananda Bharati case, the judgment of Kesavananda Goloknath case has been reversed. So number of examples are there. You will find Supreme Court is not bound, and had it been bound, then it would have been difficult for Supreme Court to change. But remember, other courts are bound by the judgment, standing judgment, unless they are changed by the Supreme Court itself. Okay, so that is the correct statement. B is the correct. Can reverse a previous decision only when a legislation is known there is no such provision. Can reverse a previous decision only when the previous decision was given as a result of overlooking another previous decision? No. So B. That is depending upon the nature or the gravity of time and situation. Supreme Court will change the decisions. Not that it does not have any meaning in the change. It has great meaning in the change. Because Supreme Court decisions are based upon the gravity and the nature of time and situation. Which one of the question number 10, which one of the following is directly related to the appellate jurisdiction of the Supreme Court? Appeals made in the civil, criminal, constitutional cases, appeals made in constitutional cases only, adjudication of disputes between union states, adjudication of disputes between states? No. So option A will be the correct option. Article 132 to 135A, there is a provision of appellate jurisdiction. Supreme Court hears appeals against the judgment of the high courts in civil, criminal and constitutional cases. A. Next is your question number 11. How can the number of judges in the Supreme Court India be increased? Supreme Court, the number of judges in the Supreme Court can be increased only by an act of Parliament. For example, the Parliament enacted the Supreme Court Number of Judges Act 2019, by which it has increased the number of judges to 33. And a Chief Justice of India, so the total strength of the Supreme Court at present is 34, and it has been done by an act of Parliament in 2019. So the strength of Supreme Court is decided by Parliament, not by President. So that is B. Question number 12. Consider the following statement. Parliament can extend but cannot curtail the jurisdiction and power of the Supreme Court. As I have already told you, Parliament cannot decrease, curtail the jurisdiction. It's correct statement. Number 1. Number 2. No discussion can take place in Parliament with respect to the conduct of any judge of the Supreme Court in the discharge of his duties. Yes. 121 bans discussion on the conduct of judges in legislatures. 3. Retired judge of Supreme Court cannot appear or plead any court before any authority within the territory of India. True. Salaries and allowances of the judges of Supreme Court are charged on the Consolidated Fund of India. That is correct. So 4 is correct. 3 is correct. Let us see 2. 1 is correct. 2 is correct. 3 is correct. 4 is correct. 1, 2, 3, 4. Answer will be 1, 2, 3, 4. A is the correct option. Question number 12. All are correct options. Which one of the following categories of disputes is excluded from the original jurisdiction of the Supreme Court? Between the Government of India and one more state, it is there. Between two or more states, it is there. Between residents of two or more states, that is correct. Incorrect. Residents of the states does not come under original jurisdictions. that may be forwarded, that may be lost in the High Court or in the High Court or in the subordinate courts. So question number 13 answer will be C. Question number 14. The rules for regulating the practices and procedure of Supreme Court are made by the Supreme Court with the approval of the President of India. That is a correct statement. Supreme Court with the previous sanction of the President. I think it is under Article 145. Okay. So that will be B, Article 145. Makes own rules and regulations. B. When the CJI is appointed by the President, he is required to consult there is no need for consultation because the senior most judge of the Supreme Court is appointed as Chief Justice. The practice is still in vogue. But here the options, maybe the D, option D will be correct. Such other judges of Supreme Court, High Court as deems necessary. Yes. There is no consultation with the executive. Which one of the following statement is not correct? A retired judge of Supreme Court is prohibited from appearing or pleading any court within the territory of India. Yes. Supreme Court may issue writs for the enforcement of any legal right within the territory of India. That is incorrect. Supreme Court cannot issue writs for other purposes except the purpose for enforcement of fundamental rights. Article 32 gives power to the Supreme Court to issue writs only for the enforcement of fundamental rights, not any legal right. The term any legal right is incorrect. So that will be the incorrect statement. Supreme Court has power to punish any person for its own contempt, Article 129. So that is incorrect. It is correct. It is correct. Salary of judges of the Supreme Court is not subject to vote of the legislature. Yes. Charged expenditure. Non-votable expenditure. B. Okay. Question number 16, answer B. The Supreme Court of India is different from its counterpart in its role as the guardian of the Constitution. No, they have both of them have the role to guard the Constitution against violation. In its advisory role, in USA there is no advisory jurisdiction. We have borrowed in fact the advisory jurisdiction from the Canadian system. So in its advisory role, we are different from American Supreme Court. In its role as the supreme authority in the judicial field, no. In its jurisdiction, no. So B. B will be the best answer. Which one of the following is correct? Correct. If the justice is to make a request for attendance of judge of High Court at the sitting of the Supreme Court as an ad hoc judge, only previous consent of the President is required. Previous consent of the President and consultation with the Chief Justice of the High Court is required. Only consultation with the Chief Justice of High Court is required. Neither previous consent, no. B will be the best answer. Both are required. Previous consent of the President of India and consultation with the Chief Justice of the High Court concerned High Court, from where the judge is hired, is required. So that is 127. 127. B. Question number 18 answer will be B. The jurisdiction of the Supreme Court of India may be enlarged by Parliament by law. Parliament by law. Okay. Question number 20. Okay, question number 20. The nature of consultation with the Chief Justice of India in matters of appointment of a judge to a High Court is correctly described as inspection of the file by the Chief Justice, concurrence of the Chief Justice. That is concurrence. In second judge case that was provided 1993, concurrence. Consultation is not optional but binding. That is concurrence. B. Getting the questions? What is the provision of safeguard to safeguard the autonomy of the Supreme Court of India? While appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. The Supreme Court judges can be removed by the Chief Justice of India only. No. There is incorrect statement. The Supreme Court judges can be removed by a resolution passed by Parliament and approved by the President. So that is not the provisions. Salaries of judges are charged on the Consolidated of India, to which the legislature does not have to vote. That is correct. All appointments of officers and staffs of Supreme Court of India are made by the government only after consultation. No, by the Supreme Court itself. By the Supreme Court itself. Appointment its of own staff. Article 146. Article 146 empowers the Supreme Court to appoint its own staff. Which of the following statement is not correct? So this one is a statement. So this will be correct. Has to consult the Chief Justice and some other judges. It only is not mentioned. So take the option 1. It will be option 1. It's not an option. It is a question. Sorry. So 1 is correct. 2 is correct. 3 is correct. No, 4 is correct. 1 is correct. 3 is correct. 4 is correct. Is there any option or not? No. Not correct. What is the provision? While appointing the judges, the Supreme President has to consult the Chief Justice of India, okay, and some other judges of the Supreme Court, that is a collegium, okay, then the statement has been taken away. So we should make 3 and 4 here, because one is not option there, because one is partially correct, not incorrect. The word only is not mentioned here. But anyway, according to the option, we have to choose 3 and 4, because 2 is completely incorrect. Option 2, here is 2, it is 3, it is 4. So 2 is completely incorrect. 3, 4 are completely correct. 1 is partial correct. Okay, 3 and 4. 3 and 4 is the answer. 3 and 4. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. No, High Court can do that. High Court has also power to review the parliamentary acts or the government or order of the center. So High Court is, in this respect, has power. So 1 is incorrect. An amendment to the Constitution of India cannot be called into question by the Supreme Court. It can be. Various amendments has been declared, reviewed. For example, recently 99th Constitutional Amendment Act 2014 has been declared null and void by the Supreme Court. So amendment, every law made by, whether amendment law, constitutional law or ordinary law, any law which is made by the parliament or state legislature will come under the judicial review. So that is cannot be reached, so it is also incorrect. It is incorrect and it is incorrect. So neither 1 nor 2. Neither 1 nor 2. D. With reference to the Constitution of prohibition or limitation of provisions contained in ordinary law cannot act as prohibition or limitation on the constitutional power of Article 142. It could mean which of the following? (142) is, as I told you already in this class, 142 gives the Supreme Court the power to issue decrees and orders for complete justice. What does it mean? Constitution of prohibition or limitation on provisions contained in ordinary law cannot act as a prohibition or limitation on the constitutional power under Article 142. Okay, the decision taken by the Election Commission of India while discharging its duties cannot be challenged? No, because 142 is related to Supreme Court. The Supreme Court of India is not constrained in the exercise of its power by laws and made by the Parliament. Okay, that will be the correct statement, I think. Let us see the option C. In the event of given grave financial crisis in the country, the President of India can declare financial emergency without the consult from the cabinet. No, that is not a accurate statement, correct statement. State legislature cannot make law on certain matters without the concurrence of the union legislature. That is also incorrect, vague statement. So option B will be the correct answer. And for your kind information, Supreme Court has the power under Article 142 to issue decrees and orders to do complete justice for the people. Okay, so that is B. Question number 25. The motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per Judges' inquiry. It can be rejected. It can be rejected. For example, in 2018, chairperson of Rajya Sabha rejected the removal resolution against Chief Justice of India, Deepak Misra. Justice Deepak Misra. The motion was rejected. So the speaker has the power to reject. So option 1, statement 1 is incorrect. Statement 2, the Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court. No, there is no definition of what constitutes incapacity and proven misbehavior. That is only mentioned. 2 is incorrect. The details of the process of impeachment of the judges of Supreme Court of India are given in Judges Enquiry Act 1968. That is a correct statement. The details are not mentioned in Article 124. The details are mentioned in the Constitution of India, not mentioned in the Constitution of India. It is mentioned under the said Act. Okay. There is only mentioned, it is not mentioned in the Constitution. The Judges Enquiry Act 1968 deals with the process of removal of judges. But remember, Article 124 that 124 clause 4 deals with the removal of judges. It says that a judge of the Supreme Court shall not be removed from office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of the House and by a majority of not less than 2/3 of the members of the House present and voting has been presented to the President in the same session for which removal on the ground of proved misbehavior and incapacity. Okay, so there is therefore only 24 mentioned, but details are mentioned in Judges Enquiry Act 1968. Next, so statement 3 is correct. Statement 2 is incorrect. Statement 1 is incorrect. Statement 4, if the motion for the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each House of the Parliament and supported by a majority of total membership of that House and by not less than 2/3 of members of that House present and voting. Yes, as I told you, 124 clause 4 deals with this factor. So 3 and 4 will be the answer. 3 and 4 will be the answer. C. Question number 25. The Supreme Court of India tenders advice to the President of India on matters of law or fact on its own initiative on any matter of larger public interest? No. If he seeks such an advice, yes. President seeks an advice, as I told you, under Article 143, only if the matters relate to the fundamental rights. No. So one will be the best answer. Because it is known as advisory jurisdiction of the Supreme Court. Advisory jurisdiction. That I have already told you, it has been borrowed from the Canadian Constitution. So 2 only. That means your option will be B. (26) Under which of the following circumstances The acting Chief Justice of India is appointed. He is acting Chief Justice of India is appointed under Article 126 of the Constitution, and he is appointed by the President in the circumstances. Let us examine the office of the CJI is vacant. The CJI is temporarily absent. Yes, CJI is unable to perform his duties, his or her duties. So D. And the article is 126. Who among the following authorizes the seat of Supreme Court of India? The CJI with previous sanction of the President. Yes. C. 130. Okay, 28. Where question is on High Court. Judiciary is an integrated one and covers Supreme Court, High Court and subordinate courts, also various other judicial arrangements. So in our sessions we will be bringing different questions related to this entire segment, entire world of judiciary. Okay, so here is a question on High Court. A common High Court for two or more states or union territory may be established by Parliament under Article 231. Common High Court can be established. Although there was a provision there shall be a High Court in each state, but by 7th Constitutional Amendment Act 1956, Parliament has been empowered to establish a common High Court for two or more states and union territories. Possible. There are 3 common High Courts today: Guwahati High Court, Bombay High Court, and Punjab and Haryana High Court. Okay, so A. (29) Under a single integrated hierarchical judicial system, the High Court in the states are directly under the Supreme Court. Therefore, we are called an integrated judicial system. D. Who decides the number of judges in High Court? The President. The President is authorized to decide the number of judges of the High Court, not by an act of Parliament, unlike the Supreme Court. So she will be the answer. The only union territory which has a High Court of its own. The question is irrelevant today because now 2 High Courts have 2 union territories have their own High Courts. One is Delhi, which is the first High Court, first union territory to have a High Court in 1966 probably, and then later Jammu Kashmir became a union territory in 2019 and it has also got a High Court. So here the question is B. But remember, Jammu and Kashmir also a union territory which has a High Court. 32. Against which of the following judges of SC wants removal proceedings was initiated V. Ramaswamy in 90s. That was the provision, but the removal resolution could not be passed by Parliament. Rajya Sabha rejected the plea. So C. Okay. Some questions related to articles of the Supreme Court. 124 establishment of Supreme Court. 129 Supreme Court to be a court of record. 133 appellate jurisdiction in civil matters. Article 134 appellate jurisdiction in criminal matters. 1, 2, 3, 4. 1, 2, 3, 4 will be the answer. Correct answer. It is 1, 2, 3, 4. So 1, 2, 3, 4 is the correct match. (34) Madhya Pradesh. Here I think the name of the high courts and the headquarters is mentioned, not clearly mentioned. High courts and their headquarters. Madhya Pradesh is in Jabalpur, Chhattisgarh in Bilaspur, Rajasthan Jodhpur, Kerala Ernakulam. 2143. 2143. And remember, these are the high courts which do not have their headquarters in the state capital. So 2143. 2143 C. Last question of the session, 35. Match article related to high courts. 214. 214 is establishment of high courts. Common high court is 231. Transfer of judges is 122. High courts to be a court of record is 120. 215. तो मैंने A4 B3 sorry A4 B3 yes B3 C2 and D1 common high court B. Okay, so we have discussed 35 questions at a range with a hope that we have discussed some level questions, and in the next class I shall be bringing other questions, some other questions related to judiciary with the next session on judiciary 3. Okay, keep watching us and giving your constructive comments. Okay, so see you in the next class.